Investigation was reviewing all exhibits and statements, correct?
It was.
After all, as you said, there was little to no forensic evidence, right?
Yes.
And one such piece of evidence you encountered was the code violation, right?
Yes.
I'd like the record to reflect that I am establishing a demonstrative of exhibit 3. May the witness step down to interact with me.
I mean, it's not your witness, so if the witness, I guess, wants to, she can, but I don't think that you can force the witness to leave her seat.
This is clearly visible to you.
Yes.
Now, during direct examination, I noticed you said that you had no concerns regarding these violations. Is that right?
Yes. These types of violations are perfectly common at construction sites. They would not have impacted the finished quality of the build, and I do not believe they would have been an issue without an instigating individual.
I'm sorry. Wouldn't you agree that we're not talking about the quality of the build, but the fire risk?
The fire risk is part of the quality of the build.
If you say so. Well, let's read from here. The ground and neutral in the sub-panel switch. Did I read that right?
Yes.
As fire marshal, wouldn't you agree that you're pretty knowledgeable on how electrical fires could start?
Yes. The wires needed fixed.
So, you say they needed fixed. Is that right?
Yes.
Yet this still wasn't a concern?
It would not be a concern if this was addressed by the care administrator.
But it wasn't addressed, was it?
I believe they were still within their time frame to be able to.
Is that a yes or no?
What was your question?
It was not addressed, was it?
Not quite that.
Now, it's my understanding that the neutral wire completes the circuit. It carries the energy in the circuit back to the source. Is that right?
Objection, Your Honor, lack of personal knowledge. This witness is not an electrician and would have no knowledge of how breaker boxes specifically work, just on how they might start fires.
May I respond? I mean, this is common knowledge that many people would have, and the witness has agreed they're already knowledgeable on how electrical fires could start. So I believe that the witness can answer this question aptly with their knowledge.
Yeah, I think it's cross-examination, so if the witness doesn't know, she's free to say that she doesn't know, and certainly considering that she's here to testify about how the fire could have started, and one potential way is an electrical fire, I think that it's fair game for opposing counsel to ask about this, but again, if the witness doesn't know, she's free to say that, so I'll overrule it, I'll allow the question to be asked.
So the neutral wire completes the circuit, right?
I just know that when wires are mixed up, it can pose a fire risk.
So you'd agree that this details a fire risk?
It could, but I do not believe it would have caused a large enough risk to start a fire without.
I'm sorry, so that is a fire risk, right?
It could be.
Yet it's still not a concern.
It's not a concern without an instigating individual.
I would like to read again. AC unit in room 313 is powered by a 120 volt wire. Requires 220 volt wire. Did I read that right?
Yes, it posed a risk in the breaker box as it could short out the breaker box.
Now,
But that would not have happened without the AC unit being turned on.
either way, this appliance would be trying to draw an inappropriate amount of current, right?
Yes, it would have.
And would this put strain on the system?
This would not have happened without it being turned on by an instigating individual.
I'm sorry, is that a yes or no?
Exactly.
And wouldn't you agree that the breaker box violation is the most egregious one?
The breaker box was a very large issue, but again, I do not believe it to be a significant enough issue to have caused a fire without someone forcibly turning on one of the appliances on the third floor, which would not have happened given it was under construction.
During opening statement, I remember hearing that they described Seneca, and I quote, they lit the match. Would you agree with that statement?
It was an electrical fire. There were no matches involved.
Now right here it says, entire third floor operating on 50-year-old comfy breaker box that was recalled decades ago due for potential for starting fire with multiple tripped breakers. Needs replaced. Did I read that right?
Yes.
And it says, above listed issues must be addressed and fixed. Otherwise, construction permit will be rescinded and progress halted. Did I read that right?
Yes.
Yet these weren't concerns.
They were not concerned without instigating an individual. As I've said, the breaker box would not trip without someone turning on the appliances.
I'd like the record to reflect I am deconstructing the demonstrative.
So, Counselor, I think that if we're talking about what the record is going to reflect, it's very important that we avoid crosstalk. We can't have the record reflect if two people are talking at once. The witness was still in the middle of giving her answer, so I'm gonna ask that you please refrain from saying anything while the witness is giving her answer. So, we're not gonna have the record reflect that. We're gonna have the witness finish her answer, and then if there's something that you'd like the record to reflect, you're welcome at that point, to have the record reflect that. So please, kind of finish what you were saying. Okay, alright, now is there something you'd like the record to reflect?
I'd like the record to reflect that I am deconstructing enlargement and establishing an enlargement of the previously entered Exhibit 2. Is this visible to you?
Yes,
Now, on direct examination, I remember you said that your two original suspects were Corey Snow and Seneca Crane, the defendant. Is that right?
yes, but before we pick suspects, we were looking at all evidence we were able to with the records and the interviews of conditions of care answering.
And part of this investigation was interviewing people, right?
It was,
And one of these people you interviewed was Astrid Everton, correct?
we did,
And you also reviewed his statement?
we did.
So you would know that Corey Snow was seen on the day of the fire with the gas mask, right?
Yes, but like,
Objection, Your Honor, hearsay. The co-counsel is referring to an out-of-court statement being the witness's testimony, which is not a piece of evidence able to be used in this witness's line of questioning.
Okay, what's your response?
My response is that these findings are from a legally authorized investigation as public records that are detailed in the witness's statement.
May I respond?
And I believe the witness has already testified to their findings and what they learned from certain people.
May I respond?
You may.
While this information may have been found in a legally authorized investigation, it is still referring to an out-of-court statement being used to prove the truth of the matter in today's proceedings, which would be Astrid Everdene's statement. And even if the witness had knowledge of that, that does not make this less hearsay.
So I think we're getting stuff a little bit mixed up here. So the quote that you got here, are we in agreement that's from Astrid Everdene's affidavit?
Yes, Your Honor.
That's where that is being pulled from, okay. So that's an out-of-court statement, and we're saying, and can you repeat for me, what is the actual statement here?
I don't know word for word, but it states that they saw Corey Snow the very day of the fire with the gas mask and the carabiner.
Okay, so are you offering that for the truth of the matter asserted to prove that Astrid Everdeen did in fact see this?
Yes.
Okay, and your response is that you're allowed to do it because under Rule 803.8, Astrid Everdeen's affidavit is a public record?
Yes.
Okay. And are you saying you agree that Astrid Everdeen's affidavit is a public record under Rule 803.8?
I don't believe Astrid Everdene's statement is recognized as a public record because I believe that refers more to like receipts and police or like various other documents, but not witness testimony.
Yeah, so I don't think a witness's affidavit is a public record. So a public record would be like something by some kind of public agency that they always have to make and that they're under a legal duty to make public. I don't think that a non-state witness's affidavit would fall under 803.8. So,
These findings would also have been found when Peter Malark interviewed Astrid Everdeen themselves as part of a legally authorized investigation of the Caravansers fire.
yeah, so that may be true that the investigation was legally authorized. That doesn't mean that anything that comes up in the investigation is therefore an exception to hearsay. Rule 803.8 is really specific that it has to be in a public record, and I don't think that this is a public record. So based on that exception, I'm gonna sustain the objection.
Wasn't Corey Snow your first suspect?
They were one of our suspects.
Or were they your very first?
I believe they were.
And they fell under the motive spite and revenge, right?
They did.
Now, the fire at the Caravansary was reported at night, correct?
It was.
And I will now read, most deadly type of arson, usually at night. Did I read that right?
Yes, but there are many other factors that go into determining the motive and investigating suspects for that motive.
Wouldn't you agree that Corey Snow and the defendant had work-related problems?
I believe they did.
I will now read again. Can be from work-related problems. Did I read that right?
Yes, but I believe there were other factors going into it, especially considering Corey Snow has worked at the Caravansary for over a decade, and they were a loyal employee for the entire time.
But correctly, yes.
He did.
During direct examination, you said that 2 of your most prominent interviews were with Corey Snow and the defendant. Isn't that right?
Yes, they were, because they were the highest motive. However, we did rule Corey Snow out.
So you only interviewed the defendant once?
We interviewed the defendant multiple times.
So you focused on the defendant multiple times after you identified Corey as having the strongest motive?
We ruled Corey Snow out, and we talked to Crane the most due to the fact that they were the owner of the Caravansary, and they could get a lot of information about the conditions at the Caravansary leading up to the fire from them.
So did you interview the defendant because they could provide background, or because you viewed them as a suspect?
We did both, with most of our initial interviews revolving around the fact they were the owner and had a lot of information, before moving on to question them about the fact that they were motive for fraud.
Are you absolutely 100% certain that the fire in the Caravansary was caused by the defendant?
I believe that it was, and based on our investigation, we have proof that means we have an opportunity to pull that.
You understand that you are under oath in today's trial? And it is your sworn testimony that you are 100% certain that the fire was caused by Senator Crane, the defendant?
I didn't say that. I said our investigation has proved that they have means, motive, and opportunity to cause that fire.
So is that a yes or no to the fact that you are certain?
I believe our investigation has proven the fact that Crane has intentionally lit the fire.
I'm sorry, is that a yes or a no? Are you certain?
Objection, Your Honor, asked and answered. I believe he's already gone over this.
May I respond?
No need, I don't think that this specific question has been asked and answered, and I think that the attorney is entitled to get a yes or a no to a yes or no question, unless the witness feels that it can't be answered with a yes or no.
Yes or no? Are you certain that the fire in the Caravansary was caused by the defendant?
Our investigation has proved that they have committed the fire.
Your Honor, the witness is unresponsive. Multiple times I have asked for a yes or no, and it is the same answer.
Then, I think that's the answer that you have. If you don't like the answer that the witness gave, you're free to ask a different question, but I think that the answer the witness gave is reasonably responsive to the question.
So you are certain that the Caravansary's fire was caused by the defendant?
To the best of our investigative abilities, considering there's no forensic evidence, I believe we have proven that the defendant caused the fire.
But you are not 100% certain, are you?
Based on my many investigations with types of fires where there is no forensic evidence, I believe we have enough investigative proof to determine that the defendant has lit the fire.
But you are not 100% certain, are you?
Objection, Your Honor, asked and answered.
Yeah, I think at this point we've gotten it. The question's been asked, and I think it's been answered, so I'll ask you to move on.
No further questions, Your Honor. I'd like the record to reflect that I am now deconstructing